She's like a veteran at this point.
I know. I don't even know why she asked. Right? Because she has to.
Permission to practice for myself too, Your Honor.
That one would be denied. You know that. All right. What are we doing on this?
This is one of those hearings where everything looks routine on the surface, but underneath, there's a storm of legal tension building in real time. You've got a defendant already walking a tightrope, prior conditions, possible violations, emotional instability, and a judge who is clearly not in the mood for confusion, excuses, or blurred boundaries. Right from the start, you can feel the courtroom energy. Fast, slightly chaotic, and filled with overlapping issues that are about to collide. What makes this case especially gripping is the combination of personal drama and strict legal structure. There's a no-contact condition in play. And in the legal world, that's not a suggestion. That's a line you do not cross under any circumstance. But now we're hearing about phone calls, possible proximity violations, and a situation involving a hospitalized mother, which introduces emotional urgency into a system that operates on rules, not sympathy. And here's where it gets interesting. When emotions clash with court orders, the court almost always wins. The question is, did the defendant knowingly violate those conditions, or is this a situation where chaos and circumstance created a gray area? Because if the judge believes this was intentional, things can escalate very quickly. Stay locked in. Because what starts as an explanation is about to turn into a credibility test.
I'm just jumping in the case, Your Honor. I'm asking for an adjournment to
maybe approach.
Oh boy. It's Monday. I have 2 cases. Really?
Ian already said it's the short dockets that take the longest. Okay, hold on. I have to stop.
She's slow.
I
know, because he just started walking.
Right.
Good.
Yes, sir.
All right. Recall the case of People versus George White.
Sam Bernstein again for Mr. White, Your Honor.
Reference, before I passed the case, we had a bench conference about some phone calls that were made, and I let you talk to your client. Also, that there at least was an indication that the defendant may have been within 1/2 mile of the excluded zone. We called over to community corrections. They've indicated that there is no violations at this point, so I'm not going to deal with that. But
this is a critical moment, and if you're paying attention, the defense is doing something very strategic here. They're getting ahead of a potential violation before the judge fully locks into it. When the court hears possible contact or proximity issue, alarms go off immediately. But here, the defense quickly introduces a key fact. No official violations have been recorded by community corrections. That matters. In legal terms, if there's no documented violation, the court doesn't have immediate grounds to punish. But that doesn't mean the concern disappears. It just means the burden shifts to explanation instead of enforcement. For now. Then comes the narrative. And this is where things get complicated. A sick mother, a hospital emergency, conflicting medical authority, and a claim that the calls were made by a nurse. Not the defendant. This is not just a legal defense. It's a human story being presented to soften what could otherwise look like a clear breach. But here's the problem. Courts don't just evaluate stories. They evaluate control. And the key issue is this. Even if someone else made the calls, did the defendant allow or facilitate contact with a protected individual? Because legally, indirect contact can still be considered a violation. Now the judge is listening, but also measuring credibility. And once that happens, every word matters. Would you believe this explanation at face value, or would you see it as a workaround?
Okay. I can address the phone calls if the court would like.
yes, please.
There is something of a story, and we're not going to litigate the probate stuff matters, but so there's been a very stressful situation going on with George White's mother being sick in the hospital. Apparently he has like an alternate medical power of attorney. The complaint he does, yes.
Okay.
Or medical power of attorney. I don't know how to phrase it. Okay. Oh, let me just go first and we'll see.
He's got the medical power.
Yes.
Okay.
But I think the victim might also have like a medical power of attorney or a claimed medical power of attorney. And so he said that he was like signing paperwork for like an immediate surgery, and that he was like stopped in the middle of signing it And they said that the other person, the victim was like wanting something different for the mother. And so he says that he gave his phone to a nurse who made the calls to the victim, that he did not call her. And that when he learned that she was there, he later went into like another section of the hospital to like stay far away from the situation.
So you're saying, just so that I'm clear, all 6 of the calls were from that?
Now the judge starts tightening the screws, and this is where courtroom dynamics shift from storytelling to precision. Notice how the judge isn't reacting emotionally. He's narrowing the focus, number of calls, timing, and consistency. That's how credibility gets tested in real time. 6 back-to-back calls? That's not casual. That suggests urgency, repetition, and potentially intent. So even if the defense claims a nurse made those calls, the judge is now asking the real question: does this pattern make sense? And then comes the second issue: an earlier call that doesn't fit the nurse explanation. This is where things start to unravel slightly, because once a timeline has gaps, the court begins to question the entire narrative. The defendant claims he wants no contact whatsoever, and that's a strong statement. But in legal proceedings, words don't carry as much weight as actions. If the record shows repeated calls, the court is going to focus on behavior, not intent. And here's the tension. The defense is trying to frame this as an emotional emergency with no malicious intent, while the court is evaluating whether boundaries were crossed, regardless of emotion. This is where many defendants make a mistake. They think explaining intent is enough, but the law is often about outcome, not intention. So now the real question becomes, is this a misunderstanding or a violation disguised as an emergency?
Yes, he says they were made like back to back to back.
That was on the 4th.
Right.
But what about the 2nd?
I don't know about this. No, I don't know. But he says, he told me he has no wish to speak with her at all, that he hasn't spoken with her, and that he doesn't want to go near her or have anything to do with her whatsoever. So he definitely doesn't, it wasn't like a don't show up to court kind of situation. He just doesn't want to have contact with her whatsoever. It seems like there may be some sort of like kind of probate-ish issue with like medical powers of attorney and who may or may not have power or something, but the appropriate forum to litigate that wouldn't be, I don't think it would be Judge Simpson. It would be another forum, and that's not really for today, I would suggest. But I think that's sort of like the backdrop of what happened here. But I mean, either way, I mean, he's not supposed to have any contact with her. And I think he knows that, and he doesn't wish to speak with her on any basis.
Jacinda.
I'll let you talk.
One of the calls was on March 2nd, and then on the 4th, one of the calls that was made was 2 hours before the back-to-back calls that were supposedly from the nurse. We would be concerned with the contact with the victim.
I won't stop you from talking if you want to contact.
First and foremost, she gave a dep while I was in jail.
She what?
A dep when the dep's in jail. I was in the tank right there. I hadn't been arraigned yet. Gave him her number to give to me. Never contacted her. I don't want to. She's a devil. She's evil like my mom. Okay, look.
And just like that, the tone of the entire hearing shifts. This is a moment where the defendant loses strategic control. And that's dangerous in a courtroom. Instead of staying focused on facts and explanations, the language becomes emotional, aggressive, and personal. Calling the alleged victim evil may reflect genuine frustration, but in front of a judge, it does something very specific. It damages credibility. Why? Because it suggests unresolved conflict. And when there's a no-contact order in place, the court's primary concern is safety and separation. So when a defendant shows emotional volatility, it reinforces the court's fear that boundaries might not be respected. Now, to be fair, the hospital situation described is intense. Vomiting blood, emergency conditions, fear of death. That's not a minor event. But here's the legal reality. Even in extreme situations, court orders don't pause automatically. There are legal ways to handle emergencies. Contacting authorities, requesting modifications, but taking matters into your own hands can backfire. And that's exactly what's happening here. The more emotional the explanation becomes, the less structured it feels. And judges rely on structure to make decisions. So now the courtroom is no longer just evaluating what happened. It's evaluating how this person reacts under pressure. And that can impact everything that comes next.
But anyways, the situation at the hospital was when she got transported from Dearborn
She
Royal,
being whom?
my mother, and I was there with her. She vomited 4 buckets of blood. She was going to die right there. But they got her to Royal
Okay,
to get
okay,
discussed.
sir.
Now, during that exact moment,
Judges talking.
oh, I'm sorry.
I agree, Mr. Bernstein, that I'm not gonna sit here to litigate the probate matter in terms of a power of attorney, but the victim's relationship to the defendant is what?
Ex-wife. See, that moment.
No, but we can't interrupt the court. It's fine.
Was the power of attorney granted after your divorce?
The power of attorney was verbally given in Dearborn and fraudulently taken.
Can you just answer my question
Sorry, yes, it was verbally, yes.
before the divorce?
Well, there was no power of attorney before we've been divorced for 1.5 years. It was given to me at Dearborn.
So, no, it wasn't.
Oh, no.
Thank you, Mr. Jeez, oh, wait. All right. Well, without doing more checking, I don't know that I can figure out these phone calls. I understand what you're saying, Miss, and I don't want the victim contacted from your phone at all, ever.
This is one of the most important lines in the entire hearing, and it's not subtle. The judge is drawing a hard, unmistakable boundary. Zero contact, no exceptions, no ambiguity. When a judge says something like "at all ever," that's not just clarification, that's a warning. It means any future violation, no matter how small or indirect, will likely result in serious consequences. We're talking about potential bond revocation, additional charges, or immediate custody. And notice the tone shift. The judge moves from listening to instructing. That's a signal that the court has heard enough explanation and is now focusing on control moving forward. Then comes the geographical restriction, the exclusion zone. This is another layer of legal containment. It's not just about who you can't contact, it's about where you can't go. And these zones are enforced strictly. What's interesting here is the defendant's confusion. He's trying to visualize the boundaries, which is understandable. But from the court's perspective, confusion is not an excuse. The responsibility is on the defendant to understand and comply fully. This is where many people slip up, not because they intend to violate, but because they don't take the restrictions seriously enough. The judge is essentially saying, "I've made this crystal clear. If you cross this line, that's on you. No gray area left."
Am I clear?
Oh, yeah, no problem.
What part of Carpenter Road do you live on?
I live on, actually, it's right there.
What are your cross streets?
I'm right in the middle between Washtenaw and Packard.
The block that I'm creating, which is the exclusion zone, is east of Carpenter, south of Washtenaw, west of Gulfside, north of Ellsworth. So that we're clear, sir, you're gonna have to stay on that west side of Carpenter Road. You're not to travel on the eastbound Carpenter at all. So if you gotta go around the block to get to your place, you're just gonna have to go around the block. Am I clear? Is that a yes?
Yes, I'm trying to picture it in my head.
What are you trying to picture in your head?
So like you say, crossing Carpenter, what about? And then it hits Washtenaw. So are you talking about that corner right there would be like exclusion, or does that also cross over to the other side of Washtenaw?
I can picture it in my mind. I'll show you on the Google Maps afterwards.
Thank you.
It's like a block. I get it.
Well, I just don't want to get it wrong. Just if I get it wrong.
You know, the gas station that's on the corner of Washtenaw and Carpenter.
Yeah, there's 2 of them right close here.
You can go on Washtenaw at that gas station, either direction, but you can't go south of Washtenaw. Does So you know Washington on the Gulf side? You can't go south. You can't go into that area.
Okay.
On Gulf side, you can't go east or west. And then Ellsworth, where Meyer is, that includes that block. Mr. Bernstein will show it to you, I'm sure.
I have it right here.
We'll have it all laid out. Got it?
Please, yeah.
Yes. Thank
That's Carpenter. That block, you cannot go in that block. Okay,
Okay.
so he's saying if there's stores along there that you like to go to, you're gonna have to go to different stores.
What if they're on my side?
Your side, fine.
Okay.
You can't go to any of those places between those streets, okay?
You can go to Kroger, Home Depot, and Lowe's.
So like there's a gas station there and there.
Can't go to Meyer.
But I can go to that
You can go
Can't
to,
go to Target.
one on like towards this jail. On the side of the road.
no, you can't go to Hobby Lobby either, George, okay?
I'll go.
You can go to that gas station. You cannot go to that gas station, okay? I'm gonna email you.
In that block.
Yes,
I just want to be clear.
it's crystal clear, Your Honor, crystal clear.
Thank you. I've signed the order.
Okay.
Creating that exclusion zone. And then we need to adjourn this out. We almost were here long enough to get to that date.
Right.
What's their name?
And just like that, it becomes official. This is no longer a discussion. It's an enforceable court order. The exclusion zone is now legally binding, and that changes everything. From this point forward, any violation isn't a misunderstanding. It's a direct breach of a signed judicial order. What stands out here is how detailed the restrictions are. Specific streets, specific blocks, even specific stores. That level of precision is intentional. It eliminates loopholes. The court is making sure there's no room for interpretation. And when the defendant asks about everyday places, gas stations, stores, it highlights the real-world impact of these orders. This isn't just a legal boundary. It affects daily life, movement, and routine decisions. But here's the reality. Once you're under court supervision, convenience becomes secondary to compliance. The judge even reinforces it multiple times. You cannot go there. You can go here. You cannot cross this line. This repetition isn't accidental. It's building a record. If the defendant violates later, the court can point back and say you were clearly informed. At this stage, the case shifts from past actions to future behavior. The court has now set the rules. The only question left is, will they be followed?
Good afternoon, Your Honor. Alexander, on behalf of the people seeking permission to practice pursuant to Michigan for Rule 8.120 under the supervision of Assistant Prosecuting Attorney Morgan Barosa.
Permission to practice is granted.
Bridget Coons on behalf of Mr. Vasher.
All right. Your name, sir?
Thomas Vasher, Your Honor.
Thank you. All right. And what are we doing?
We were originally going to set this from final settlement conference. It's my understanding, though, that the prosecution plans on increasing this to a felony charge.
And that is correct, Your Honor. We were going to reauthorize this as a felony strangulation. That's in the police report.
Okay. And so when were you intending on doing that?
Your Honor, we were going to do that this afternoon. There was an offer and it was to plead as charged. And then the new case wouldn't be authorized.
Got it. Okay, so you're going to authorize a felony and ultimately dismiss this.
That's correct, Your Honor.
Well, if it's authorized today, I'd like to get him on the PCC docket as soon as possible since he's in custody. I mean, he might remain in custody, but you want to get that one moving as quickly as possible.
Assistant Prosecuting Attorney Morgan Barosa on behalf of the people. I do just want to note that he does have multiple circuit court matters on all of which his bond is denied, and those aren't set until April 4th. So he's going to be in
Regardless. Okay, got it.
Now the broader picture starts to come into focus, and it's not favorable for the defendant. Multiple active cases, bonds denied across the board, and upcoming court dates. This tells the judge something critical. This is not an isolated situation. When a defendant has several pending matters, especially at the circuit court level, it signals a pattern that the court cannot ignore. Bond denial is especially important here. That means other judges have already determined that release is not appropriate, either due to risk factors, severity of charges, or concerns about compliance. So even if this particular case had flexibility, the reality is the defendant is effectively locked in place because of the bigger legal picture. And here's where strategy becomes limited. The defense can argue for leniency, adjustments, and/or reconsideration, but when multiple cases stack up, the court shifts from individual analysis to risk management. The judge even acknowledges this, not to delay proceedings, but to recognize that regardless of what happens here, the defendant's custody status is tied to other cases. This is a turning point where the courtroom stops focusing on a single issue and starts evaluating the defendant as a whole. And that's rarely a position you want to be in.
Until,
That's not to say that we're gonna delay and re.
No, I
just
understand.
want you to know.
I understand. All right, when's my next date on this docket?
April 1st at 1 p.m.
So I'll adjourn this matter then to April 1st, 2024 at 1 p.m. And then hopefully what's today, the 18th, if that gets authorized. He actually may see me before then on the PCC docket.
can I get a chance to speak?
If you'd like.
If all possible, can I get a low bond in case I can make bond?
Well,
I'm going through a situation where, if you can't see, I'm terminally ill, so I don't know how much longer I have. I got life that I'm trying to spend a little bit of time with my son.
This is one of the most emotionally charged moments in the hearing, and it introduces a powerful human element into an otherwise structured legal process. The defendant is now appealing directly to the court, not through legal arguments, but through personal circumstances, claiming terminal illness, limited time, and a desire to spend that time with family. These kinds of statements are designed to invoke compassion, and sometimes they can influence outcomes. But here's the key distinction. Courts operate on verified information, not just statements. Claims like this typically require documentation, medical records, and formal verification. Without that, the judge cannot base a legal decision solely on what is said in the moment. And notice how quickly the conversation shifts back to legal realities. Other cases, denied bonds, city and procedural constraints. That's because even compelling personal circumstances don't override structural limitations within the system. This creates a stark contrast. Human urgency versus legal rigidity. The defendant is essentially asking for an exception, but the system is designed to minimize exceptions, especially when multiple risk factors are present. So the question becomes, should emotional circumstances influence legal decisions in cases like this, or should the system remain strictly procedural no matter what?
This case here, not worried about it, nor am I worried about none of my cases, because no one's coming. There's no wrong been done.
hold on,
That's
hold
okay.
on. I don't want you to say anything about the case.
I'm not.
Okay,
Uh,
here's what I'll do. How many other, but
all of them.
those other cases, he wouldn't get out in any respect because bond's denied. They're not going to hear it till the 4th, which would likely be the earliest time at which they do it. So what I'm going to do in this case is I'm going to leave your bond where it is in this case. Let the felony authorization take place, see what happens on the 4th, and then see what we can do regarding that.
I actually go for what is it where you go and ask for a bond reduction again on the 21st when I go see for my other case.
On the 21st,
On the 21st, I have
hold on a second.
Your Honor, he has an malicious destruction of police property, a controlled substance, an R&O, another controlled substance, and another malicious destruction of police property, all of which bond are denied, all of which are set for the 4th. But there's also a hold out of Van Buren.
The bonds
which
were not
looks
denied.
Like bond is denied as well.
the bonds were not denied in none of the R&Os.
So you don't see anything set for the
No.
21st?
The only date that is not the 4th, there is one in 14B, that's a contempt of court set for the 21st.
Okay,
But that's 14B.
B's case, got it. So,
Everything else is circuit court.
all right,
But I'm on the whole, I should be here until the 14th because that's when I'm scheduled for the reentry into the program. But if at all possible,
the 14th of what?
the next month, but my sister's trying to make it to where she can pay the 30,000 on my bond to get me home, and they've already went.
Okay, if they paid the
they're the
30,000
ones who set up the
Right.
hearing for me on the 21st. So.
All right, but if they pay the 30,000 on this case, you're still held on, and even if you resolve and somehow get out or have a bond on the 14B matter, you still have the bonds denied, which aren't going to be addressed until the 4th of April.
Okay.
So given what's happening in this case, given all of that, I'm going to continue this bond as is. So the bond will continue in this matter. Thank you.
Thank you.
Thank you, Your Honor.
Good morning, Your Honor. Deborah Schlossberg, on behalf of the defendant, Mr. Adrian Lottie, Dr. Adrian Lottie, who is approaching. Your Honor, to take the date and time set for sentencing. Dr. Lottie and I are in receipt of the pre-sentence report. We have no additions, deletions, or corrections. Your Honor, Dr. Lottie has no criminal record until this case. He's about to be 77 years old. He cares for his mother, who's about to turn 104. On the night in question, we know this is not an excuse, but his mother had been hospitalized, and he got a call from the hospital that something was wrong, and he immediately went to the hospital. When he had drank alcohol that night, when he drank alcohol, he did not expect to be going anywhere. He knows that he should have called a friend or called Uber, but this was his mother, who's very old, and that he was taking care of, and just rushed there to attend to her and see what was going on.
Now we transition into a completely different type of case, and the contrast is striking. Here, the defense is presenting a mitigation narrative, not denying the wrongdoing, but explaining the circumstances around it. This is a common strategy in sentencing phases. Acknowledge the mistake, then humanize the defendant. And the details matter. A 77-year-old man, no prior criminal record, decades of community service, involvement in civil rights, and a life of professional contribution. This is a profile designed to show that this incident is an exception, not a pattern. The incident itself, drinking and then driving due to a medical emergency involving his mother, introduces a moral gray area. Legally, it's still an offense, but emotionally, it becomes more complex. And the defense also highlights compliance. Months of sober monitoring with no violations. That's a strong point, because courts often look for demonstrated behavior change, not just promises. And then comes the request: reduce testing, reduce probation, possibly eliminate it altogether. This is where the judge has to balance two things: accountability and proportionality. The question becomes, how do you sentence someone who made a serious mistake but does not fit the typical profile of a repeat offender?
He's sorry that he did that. Your Honor, he has a very impressive life. He's been very active in the civil rights movement. He's also a college professor. He teaches civil rights law, and he was very active in several organizations in the city of Detroit with regard to civil rights over decades. Your Honor, he's got a CV that's over 20 pages long. He does a tremendous amount of community service and educating the community. He also is a real estate agent and an expert witness in trials and other legal matters. Your Honor, because he cares for his mother, she often gets up at 2 or 3 in the morning in the middle of the night. And so testing on the SoberLink has been difficult for him because he had a stroke a few years ago, and he's required to get a certain amount of hours of sleep because not enough sleep causes high blood pressure, and that's why he had his stroke. Your Honor, so we are asking, even though it says to continue with the SoberLink for 30 days, he has been compliant with the SoberLink. He hasn't had a single incident, and it's been many months that he's been on it. We're asking that you consider either doing away with it or that you consider lessening the amount of testing. He says that the most difficult time to wake up to test is the one at 6 a.m. because he is up in the middle of the night caring for his mother, and then he tries to go to sleep. So if Your Honor would consider maybe cutting the amount of testing or giving him a later testing time, we would appreciate it. I think he's currently testing 3 times, so we would ask for 2. Your Honor, also, we would ask possibly if there could be less than a 9-month probation term. I mean, he's almost 77, never had an incident until this. It's an aberration. It's not who he is. And as you know, the presumption is against probation for a case like for first time OWIs. And we would ask that you also possibly consider no probation. Your Honor, he would like to say something to the court.
Doctor, what would you like to tell the court?
Just that I'm very sorry and remorseful about all the trouble I caused to all the people involved in this. And when I took the victim impact course, I had already had some sense of the trouble that drinking and driving causes, but I hadn't really internalized it as much as I did after seeing the class. That made me kind of realize it more. I have myself been victim of drunk driving, but I never got hurt. I just got car damage, sometimes pretty badly, but that still didn't give me the same sense that video gave me. When I took that course, that gave me a much stronger sense of just what it does to people physically and psychologically. So I'm very remorseful about that. Excuse me.
The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe that there are reasonable grounds to depart from a non-probationary sentence. Particularly, the alcohol screening and assessment identifies the benefit of an early intervention program and abstinence from all intoxicants. Probation, the court will then follow the recommendation of probation for probationary supervision with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment.
This is a textbook example of structured judicial reasoning. The judge acknowledges that the offense is not classified as the most severe category, but still identifies a need for intervention. That's key. The court isn't just punishing, it's aiming to prevent future incidents. Probation here serves multiple purposes: monitoring, rehabilitation, and accountability. The mention of alcohol assessment and early intervention programs shows that the court is focusing on root causes, not just consequences. And importantly, the judge rejects the request to reduce testing. That decision is deliberate. The court is essentially saying compliance so far is good, but continued structure is necessary to ensure long-term change. The alternative, jail time, is also mentioned. This reinforces that the current sentence is already a form of leniency. The defendant is being given an opportunity to remain in the community under supervision rather than serve immediate incarceration. Financial penalties are also imposed: fines, costs, and fees, which are standard but still significant. This moment highlights the balance courts try to maintain: accountability without excessive punishment, structure without unnecessary severity, and in this case, the court leans toward controlled rehabilitation.
Therefore, the sentence of the court, I'll place you on probation for a period of 9 months. You are to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $270 probation oversight fee. When can you pay that?
Your Honor, can you have a payment plan?
Does he have anything today?
Oh, yes.
What can you pay today? Tell the judge.
I don't know. How much is that altogether?
Give me a total.
1325.
Half, okay. 1/2 today. And then the balance is arranged by probation on a payment plan.
Thank you, Your Honor.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to testing as requested by probation. You are to complete an alcohol awareness program and to do that within the next 60 days. You're to provide proof of the victim's impact panel attendance to probation. You've completed that. With regard to the SoberLink will continue for a period of 30 days in lieu of the 4 days in jail. I'm not going to reduce the testing. It's the program that I have in place. I'm doing that in lieu of what would be part of my sentence, which might be 4 days in jail. So I'm giving him that as an alternative to it.
Thank you.
I'll order 93 days in jail, credit 1, the balance is suspended. Thank you.
Thank you, Your Honor.
All right. My understanding there's a motion.
That's correct, Your Honor.
Go ahead.
Yes, Your Honor. I had filed a motion to ask the court to consider allowing Mr. Petitprin to withdraw his plea. The basis for the request is that his plea was not made knowing or voluntary, in the sense that he did not have all of the information that he would need to have to make the plea relative to his discovery. He indicated to me after our first meeting that he had never seen his police report. I was able to get it from Ms. Hightower, as I had just been appointed on the case to review it with him. He didn't know that some of the information he contemplated being present was actually, in fact, addressed in the police report, and he would have considered taking his case to trial had he known that. He also had never seen the video footage from the dash cam or body cam that was available to him, and has asked that the court consider that in the interest of justice as well, allowing him to withdraw his plea so that he can make an informed decision moving forward as to how to proceed. I had discussed this with the prosecution in hopes of maybe trying to resolve the case in an alternative way, and we could stipulate to the withdrawal of the plea. There was some discussions as to potential other settlements, but at this time, we've not reached an agreement on that, and we're just waiting on the court to issue a decision.
Okay, based upon what I have in front of me, there was a request either for an evidentiary hearing on that. I don't know if that is still the request. If he's saying he didn't see the information, this defendant had been before the court on numerous occasions. Adjourning everything out so that the defendant could indeed review the materials and other things regarding this case. I am having a hard time believing that he didn't have that information from counsel or otherwise have requested that information and or refused it.
No, thank you though.
To talk to you?
To me?
Yeah.
Oh, hold on. So what he has explained to me is that he requested this many times and was granted adjournments to be allowed to review, but he had never reviewed it. So that's the position that he's maintained. If the court is inclined to schedule an evidentiary hearing on that issue, I understand, and I'll explain that to Mr. Petitprin.
All right, because my inclination would be to deny his motion. I mean, I find it hard to believe that this matter had been pending since May of 2023. He enters his plea on October 4th, but that's of course after he's been out on bench warrant status. And then he's going to indicate that in essence, he knew nothing about the case or what was contained in the report prior to entry of his plea. I'm having a very difficult time believing that. So I will need his previous counsel to indicate what has happened on that. So I'll set an evidentiary hearing. I'll set that hearing for April 10th, 2024 at 3 p.m.
And Your Honor, will that be in person or by Zoom?
in person.
Thank you.
Thank you.
And you'll need to subpoena previous counsel here.
Thank you, Your Honor.
You're welcome.
This final segment brings us into a different legal issue entirely, the attempt to withdraw a plea. And the judge's response is telling. Withdrawing a plea is not simple. Once a defendant enters a plea, especially after multiple court appearances and time to review evidence, the court expects that decision to be informed and voluntary. Here, the argument is that the defendant didn't have full access to discovery, police reports, video footage, and therefore couldn't make an informed decision. On paper, that's a serious claim, but the judge isn't convinced. Why? Because of timeline and opportunity. The case has been active for months. There were multiple chances to review evidence. So the court is questioning credibility again, not just of the facts, but of the claim itself. instead of outright denial, and the judge sets an evidentiary hearing. That's significant. It means the court is willing to examine the claim, but requires proof, testimony, and possibly prior counsel to clarify what actually happened. This reinforces a core principle. The court doesn't rely on assertions. It relies on evidence. Now stepping back, this entire hearing showcases multiple layers of the legal system. Enforcement of strict no-contact orders, escalation from lower charges to felonies, the impact of multiple active cases, emotional appeals versus legal structure, sentencing based on rehabilitation versus punishment, and procedural challenges like withdrawing a plea. Each moment reflects a different function of the courtroom: control, evaluation, decision-making, and verification. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments and don't forget to subscribe for more jaw-dropping courtroom breakdowns.